Imagine the joy of reuniting with your loved one, building a life together in a new country. It is an exciting journey filled with anticipation, but a natural question that arises for many is about the financial aspects of bringing a spouse to the United States. Understanding the costs involved is a crucial step in this process. There is not one single fixed total cost for a spouse visa application, as it involves several distinct fees and potential additional expenses. The primary government filing fees alone typically range from around $1,000 to $100 to about $2,500, depending on the specific application process and whether your spouse is applying from inside or outside the United States. The reason for this variation lies in the different components of the application. For instance, you will likely pay a fee for the Form I-130 petition for alien relative, which is the initial step for all family-based petitions. If your spouse is already in the United States and applying for adjustment of status, additional fees for the Form I-480 of application to register permanent residence or adjust status, biometrics, and the medical examination will be required. For those applying from abroad through consular processing, there will be fees for the immigrant visa application, the medical examination conducted by an approved panel physician, and the immigrant visa issuance fee. These fees can also change over time, and the United States Citizenship and Immigration Services, or USCIS, updates them periodically. To get a clearer estimate tailored to your specific situation, you should first identify whether your spouse will be undergoing adjustment of status in the United States or consular processing through a United States embassy or consulate abroad. Next, carefully review the official United States Citizenship and Immigration Services website for the most current fee schedule for each form. It is also highly recommended to budget for potential additional costs, such as document translation services if any of your supporting documents are not in English, travel expenses for interviews or medical exams, and postage or courier fees for sending applications. Many applicants also choose to consult with an immigration attorney, which is an additional cost but can provide invaluable guidance. Understanding the difference between adjustment of status and consular processing is key. Adjustment of status allows your spouse to become a lawful permanent resident without leaving the United States, typically if they entered legally. Consular processing, on the other hand, means your spouse applies for the immigrant visa at a United States embassy or consulate in their home country. Both paths involve the initial Form I-130 petition. Another important component is the Affidavit of Support, or Form I-864, which is filed by the petitioner to show they can financially support their spouse, preventing them from becoming a public charge. While this form itself often has no separate fee, it is an essential part of demonstrating financial capability. By breaking down the spouse visa application into its various components and understanding the different fee structures, you can approach the process with confidence and better financial preparation. This proactive planning allows you to navigate the path toward family reunification more smoothly, ultimately leading to the exciting moment when you and your spouse can begin your new life together.